Hello, good evening, everyone, and welcome to this Cap Times talk about surveillance capitalism in the digital age. I'm Jessie Opoien. I'm the Capital Bureau Chief for the Cap Times, and with me is Jon Leibowitz, a former chairman of the Federal Trade Commission. Before we get started, I'd like to extend a big thank you to the La Follette School of Public Affairs at UW-Madison, which is hosting Jon as its policymaker in residence and is also our partner in putting on this event. The Policymaker in Residence program is sponsored by a gift from former U.S. Senator Herb Kohl through the Kohl Initiative. I would also like to thank our many Cap Times members who are joining us tonight. Your support helps make it possible for us to put on events like this one. And if you're not a Cap Times member already and you're interested in learning more, you can visit us at membership.captimes.com. And we will put that link into the chat because we'd really like to get you in that program. And speaking of the chat, that is the place to go. If you have questions for Jon, we will be taking questions throughout the evening. We'll be checking throughout our talk tonight as the hour goes along, monitoring the questions, and I will try to fit as many of them in as I possibly can as we move along. So without further delay, Jon, thank you so much for joining us tonight.
Oh, thank you for having me.
So you're based in DC now, but I understand you do have a few Wisconsin connections.
I do. I went to the University of Wisconsin in the late 70s and early 80s. I loved it here. I was not a particularly good student in high school, but I more or less blossomed at the University of Wisconsin. I studied history. And then I went back east for law school and had been in DC since the mid 1980s. But yes, and I worked for Herb Kohl also, who I see you have a cheesehead behind you. I only wish I had worn my Bucks hat tonight. He was a wonderful boss. I think we all know he was very low key, but he was a great boss. He passed an enormous amount of legislation, sometimes under the radar screen, and always for the benefit of consumers and the people of Wisconsin.
And no doubt we are grateful for the Bucks legacy in addition to many other things, but especially that right now.
I think that's probably true. Some important gun control work as well, but we can talk about that later. It's not really on topic tonight.
No, and so on topic, the FTC, it oversees a lot of consumer protection efforts, but we're here tonight to talk specifically about big tech, surveillance capitalism, privacy. And so for starters, a question that I got a lot as I was sharing this event with people is, what is surveillance capitalism?
So people have different definitions of what surveillance capitalism is. It's often in the eye of the beholder. But I think it's a pretty simple and maybe somewhat brutal concept, at least to me. It's like companies take consumers' data and monetize it in various ways. That's your data, that's my data, that's the data of everybody here. And underlying that belief is a notion that this practice is good for you, even if you haven't consented to it. And the companies get to choose, not the consumers. Now, 100 years ago, or almost 100 years ago, Justice Brandeis in Olmstead versus the United States called privacy the most comprehensive of rights and the right most valued by civilized men. He would have said civilized men and women, or civilized women and men, or civilized people. But how do we get that concept so wrong today? That, some companies, including some very large ones like Google and Facebook, have told consumers that they won't share their data, but then they did, against the consumer's wishes and against their own representations. And then two, and this was a practice that concerned, both of these practices obviously concerned us at the FTC, was the notion that when you surf the web, invisible data collectors, we used to call them cyberazzi, somewhat jokingly, but somewhat also seriously, report on your online travels to a variety of marketing firms who in turn sell an astonishingly complete profile of all of us, and our cyber behaviors. And so the notion that your private information becomes a commodity out of your control when you surf the internet is pretty troubling, and it happens certainly when you get cookies installed on your computer. And if you go on a website, you could have 100 cookies installed on your computer in 2 minutes, and they travel, and they travel with you wherever you go. And then these companies monetize that information. And in fact, they do it without your consent. So That's what sort of surveillance capitalism is, at least from my perspective, right? It is companies taking consumers' data and monetizing it in ways that they should not, in ways that the consumer, not the company, should control.
So yeah, I do have a question about that. I mean, I think we're aware of the fact that we've signed over a lot of our rights to privacy. We signed over a lot of our information, but you're talking about information that's being gathered without our consent. Where is that line? And I mean, how is that possible? How can that happen?
Well, I would say it's possible. So look, the line is different for different practices, right? If a company engaged in unfair or deceptive acts or practices, which is in violation of the FTC Act, the FTC or a state attorney general, you have a very good state attorney general in Wisconsin, will go after that company and put them under order or sue them for engaging in, for violating the law. But for something like just sucking up your data on the web, again, like cyberazzi or like a virtual Hoover, there's no prohibition on doing it, even though it seems wrong. Your computer is your property and your information should be your own. And so that's why we called for at the FTC privacy legislation that would ban this practice. And that's why some states in the European Union have also actually put restrictions on the selling of data or the collecting of data.
So at this point, should we assume that any element of our lives is not being tracked by tech companies?
No, you should assume that pretty much. I mean, look, the profiles that these companies make of you or me or others, they're from IP addresses. It's not like Jon Leibowitz that they know. But this information is sold to data brokers. Data brokers put together online and offline information, and so it's conceivable that somewhere, and certainly if you're on a big social network or you are doing lots of searches on the dominant search engine or the dominant social network, they have a pretty amazing profile of you, even if they don't actually know your name. And of course, maybe they do.
And I mean, this is a very small question for probably a big answer, but what is the advantage? Why do they want this? Why do they want that profile?
Well, look, I think advertisers and large tech companies would say we benefit consumers by serving them ads for the things that they want, right? And they get our benefits for free. And then the other thing that they would say, they don't lead with this, but it's true, is they're in the business of making money, right? And the way they make money is by collecting information and by having the most granular profiles of you that they possibly can. And and they might have started with a fair amount of idealism, particularly the biggest technology companies. But I think that idealism has given way to, I don't want to say an insatiable need for profits, but certainly to the profit maximization that you see in a lot of corporations. And maybe not the being a good cyber neighbor or being a good custodian of the internet. Reasonably disagree, but pretty much every Republican and every Democrat thinks that in Washington.
We do have a first audience question, which I think is a good one to put in here right now, and that is just really simply, what data do the various companies take from us? What's being collected?
Well, I would say when you are on a Facebook or a Google, they see your searches, they see your interactions, they collect it. Now they may anonymize it in some ways, which is good. And I don't think either Google or Facebook, and certainly not Apple, sells that information. But they're collecting, information about you through your browsing, through your interactions with other people. And again, Look, to some individuals, that's totally fine. To other individuals, they may not want some of that to happen. And particularly when you're dealing with third parties you don't have any interaction with, right? It's a little bit different with a first party when you have a bargain, when there's a trade potentially. But when it's the sort of cyberazzi that put cookies on your computer and track you around the internet, that's not only wrong, it is unacceptable. Unfortunately, it's not illegal.
So I'm going a little down this rabbit hole right now, but this sparked a question that I've always had, which is like, I'm sitting around talking to my friends. We mentioned we're going to go to Costco or something, right? This is actually a real example. I open Instagram and like 10 minutes later, I have an ad for Costco. I mean, is that happening? Is that really?
Well, Jessie, that might be the implant you have, the implant of the chip you have in your brain. No,
Is that because I got the vaccine?
There's no doubt if you're talking to your friends, if you're like, for a while, I think that I believe, I don't want to say this for sure, I think they stopped doing this, but for a while, I think Google was mining that information from, Gmail, right? So if you said Costco in Gmail, you would see a Costco ad, right? I think also if you're, if you're talking, if you're communicating through the internet in various ways, it's very possible that someone picks up that information and sends you back a Costco ad. I mean, let's just keep in mind, it's unlikely to be coincidental, right? Right.
Fair. So, we've handed over a lot of information to these companies in the name of convenience. And I think, we're aware of it sometimes at the time, like, yes, I want to let Facebook log into this app because it'll save me time and, whatever. But it's not just convenience. I mean, it's really hard to function in the world if you're not using a smartphone, if you're not on social media, if you don't have a Gmail account. So how does that kind of factor into why this is problematic and, why it's more than just convenience? It's almost essential.
Look, nobody wants to take away the ability of companies to benefit you in the ways that they do. I think what the FTC has said in the legislation we proposed 10 years ago, or the report we wrote, which called for legislation, that legislation is sort of pending on the Hill. And in the report we wrote called Protecting Consumer Privacy in an Era of Rapid Change, I think we basically tried to say we have to strike the right balance. And the burden shouldn't be on the consumers. It should be on the companies, right? The consumers should be able to determine what information they want to share and what information they don't. So
I may be actually a little bit too defeatist about this, but that's what happens when you're a journalist, right? You become a cynic. But, as you said earlier, we should assume, right, that they're tracking everything for the most part of using these services. I tend to assume, all right, I've already signed over all of my privacy at this point. Maybe I should just embrace the convenience and go for it. Why should people like me who are feeling that not succumb to that?
So look, I mean, I get the sort of notion that the computer is out of the barn sort of problem, right? Because there's so much data out there. But I think going forward, and it's hard to get back, there's no doubt about that. But I also think that going forward, you should try to protect, privacy, consumer privacy should be protected. And again, consumers should be in control about whether they want to share their own data. Now, there may be some circumstances, whether it's a matter of sort of, government investigation or billing purposes, where your company or your broadband provider needs to know what you were doing. But for the most part, we believe in privacy in the United States. We believe in the consumer's right to control his or his personal information. And that's not happening now. So I'll tell you, when I was at the FTC, and when I first got there in 2004 as a Democratic commissioner on the commission, it was then a very collegial place where we all talked with each other. I was the only Democrat for a while. It was 3 Republicans, 1 independent, and me. And we started doing some things, and we started learning more about privacy, I guess, as we went along. Because keep in mind that in the 1990s, with the beginnings of the internet and email for everybody, people recognized, I would say, the benefits of the internet and of internet engagement, but they didn't recognize the perils, right? So one of the areas we started to get involved in at the FTC was spyware. This is in like 2005, 2006. And the commission actually brought a bunch of spyware cases. Spyware is basically when someone puts malware in your computer that serves up ads. It might also destroy the computer. We had examples of that. And then they were just making money, and you couldn't get rid of the software embedded in your computer that was serving you up ads. And every time someone clicked on the ad, or every time the ad sort of, was sent to you, these companies would make money. Of course, it was in violation. They were actually intruding on your property in a certain way. So we brought those cases. We also started to bring cases for companies that had inadequate data security, right? And if you have inadequate data security, then you're much more prone to a cyber attack from a hacker, from a nation, from someone in Russia or Kazakhstan. But those were the sort of, I guess I would say they were important cases, but they were sort of low-hanging fruit, right? And so, again, it was a time when there was a much more positive attitude towards big tech. Remember Section 230 was enacted in the late 1990s that limited platform liability. John McCain had a provision that, or was adamant and had a law passed that prohibited internet sales tax for a while, right? Or sales tax for internet sales, tax for internet sales. And so, Congress, again, saw the promise of technology, but not the perils. But we began to see the perils because the FTC is an expert agency that focuses on privacy issues. And so when I became chair in 2009, and after consulting with all the commissioners, I was the only Democrat. It was a Democrat, an independent, and 2 Republicans. We decided that we would make privacy. We didn't call it surveillance capitalism then. We might call it that now, at least some of us. But we decided that we would make consumer privacy a major focus. And the commission, to its credit, had a sort of a kind of utilitarian approach, sort of the greatest good for the greatest number of people. So we prioritized areas where we could do the most good. So one was healthcare, where we tried to stop pay-for-delay pharmaceutical settlements between brands and generics, where the brands paid off the generics brands paid the generics to sit it out for a few years, and consumers were left holding the bag. It was win-win for the companies. But another area was privacy. And so we did a few things. The first thing we did was we prioritized enforcement. And we brought multiple cases against companies that violated their commitment to consumers. And that included a case against Facebook. Oh. All right. Whether we're recorded or not, I plan to speak, darn it. The FTC in 2019 found that the Cambridge Analytica debacle was a violation to that order. They sued the company and extracted $5 billion in fines. That was the largest fine ever for the FTC, and for an agency that has a budget of around $300 million a year. That was pretty substantial. They didn't sue the CEO or the chief operating officer, both of whom had committed that they would not that they would be on top of the first violation, and that they wouldn't have any more privacy. They wouldn't allow any more privacy violations or unfair deceptive acts or practices to take place. And many people, I think they should have. And there were 2 dissents on that, saying they should have. Because sometimes if you put the leaders of a company under order, it makes them think a lot about going forward. So that was one thing we did. Another thing we did was we wrote a report on privacy. I think I mentioned that before, in which we called for more consumer control over their own data, more transparency by companies, more privacy by design. Jessie, when you are inventing that really cool app, make sure you bake in privacy protections instead of finding out you need privacy protections, when some governmental body sends you an investigative demand. And we also called for legislation, privacy legislation that would provide the ability to any consumer to opt out for non-sensitive data, and would require companies to get affirmative express consent, so a form of opt-in, but a stronger form of opt-in for any the collection of any data in a sensitive category, think financial or health outside of HIPAA. We also put special emphasis on vulnerable populations like children, and we updated the Children's Online Privacy Protection Act. I can talk more about that if you want, because it was actually a really good thing we all felt very proud of at the FTC. In 2000, when Ed Markey and John McCain and others passed that act, it was designed to make sure that parents would be the gatekeepers for the collecting of information of their children, right? You had to go to the parents if you wanted to collect information of children 12 and under. But in the decade between 2000 and 2010, some companies had designed around it. They were using things called plugins that weren't technically in the regulations or the law, and to collect data of kids 12 and under. I mean, these are like young kids, right? A lot of us thought that the COPPA limit should be, Children's Online Privacy Protection Act limit should be children 16 and under, but these were children 12 and under, and they were collecting data from them. They were also collecting photos from them, collecting precise geolocation information. Now, when COPPA was passed, no one knew what precise geolocation information was, but we did by 2010. So we updated the rule and made all those things prohibitions. And even though there was some partisan dissent on the FTC, with a lot of businesses lobbying against our amendment, strengthening the act seems to have worked, and the FTC is actually going to look at it again to do some more updates, because you always want to make sure the technology doesn't elide around prohibitions, right, to the detriment of consumers, particularly vulnerable young consumers. And the fourth thing we did is we tried to get easier regulatory authority, and we got it through the House in Dodd-Frank, and we did not get it through the Senate. And then in the conference committee, Chris Dodd killed it. So, go figure. Why was that? Anyway, so we did so I would say when I was at the FTC, we made some progress on privacy, particularly on vulnerable populations and enforcement, but we left a lot of unfinished business.
And what is that unfinished business from where you sit? What do you wish you could have gotten done?
So look, if we got an easier rulemaking, the FTC is under a medieval form of rulemaking called the Magnuson-Moss Act. It makes rules very difficult to do. And in fact, the FTC, although it may start a new Magnuson-Moss Act, and I may come back to that, Magnuson-Moss regulation, hasn't started a new Mag-Moss Act in 1979. They take 5 years. So if we had been able to get easier rulemaking and finding authority for first-time violators or malefactors, that would have been good. And I think, there's plenty of unfinished business when you leave a commission, right? I mean, we could have more hours of discussion, either just on privacy or consumer protection or also on antitrust. But I would say, the one thing that maybe we should have pushed harder for at the time, and maybe that would have helped, would have been a privacy law. And, now there's a lot of interest in Congress to do that. And I think there's some possibility they will. But when you look back from 8 years away, you can think of a lot of things that you would have done maybe differently, but we did some good things. And we did it. And by the way, we also did it in a very bipartisan way, which is also the best way that your regulations or your enforcement or your laws will have legitimacy, is, when you do it working not just on your side of the aisle, but across the aisle. A Herb Cole lesson, by the way.
Fair enough. So, you alluded to this earlier. You talked about the Brandeis ruling, and you're talking now about potentially, enacting a privacy law. So do we have a right to privacy, and does that need to be, I guess, like you said, sort of enshrined more explicitly in law?
Yes, we have a right to privacy, and yes, it needs to be enshrined more specifically in law. And it needs to be done, I would say, at the federal level, you can have a handful of states, California being one, I think Arizona is another, Virginia is a third, have passed privacy laws. And, they show a couple of things. One is that state legislatures or lawmakers actually can pass legislation to benefit consumer privacy. But we all understand, everyone from the left to the right, and anyone who thinks about this knows that, data data flows in interstate commerce. It flows around the world. And so why should a consumer in Madison or in Milwaukee have less protections, than someone in Sacramento? Right? It's just everyone deserves a high level of privacy protection, and that can really be achieved. And so, for example, California's CCPA, it's the California law. It was slightly modified last year in an initiative, but that's only really restricts the transmission of information from one company to another, or the sale of information. Why shouldn't there be limits on collection? And the leading Democratic and Republican bills would do that. It's stronger.
So overall, looking at the federal level, what's your assessment of the mood, the appetite for efforts to curb the influence of big tech?
So I would say that there's a growing interest in doing it in Washington. It's from the left and the right. They're both. If you look at, for example, the rhetoric of Ted Cruz, big tech is a threat to democracy, and the rhetoric of Elizabeth Warren, big tech is a threat to democracy. It's kind of the same. Elizabeth Warren, actually, I don't think she's quite said that, but she said some things close to it, and she's introduced legislation to break up large tech companies. So I think at a political level, there is an interest in scrutinizing big tech. I think there's also about an 85% agreement between Democrats and Republicans about what should be in a bill. So, even in a dysfunctional Congress, and it's a pretty dysfunctional Congress, I think, it has been for quite some time, that makes it possible. There's some issues that have to be resolved, like whether there should be a private right of action, but there are also some discussions about compromises that have been taking place. So it's possible that we could see some movement forward. I'd also say that there's overwhelming public support for curbing, for giving consumers more control over their own data for privacy protection. I think 86% of Democrats and 81% of Republicans all support national privacy law, according to polling I've seen. And that's good, and that's rare, because as you know, we were a much more partisan country now, but here's something they agree on. And then finally, there's a lot of interest in the White House, or at the White House, in a variety of ways in curbing the powers of, I would say, particularly big tech, but also in privacy protection. Tim Wu, who worked with me at the FTC and who coined the term net neutrality, is now at the National Economic Council, and he was part of writing an executive order on antitrust this summer that had some rhetoric on privacy. Bruce Reed, who is the deputy chief of staff, was very involved in writing the California Consumer Privacy Act, the CCPA, and I think it goes, at least at some level, it goes up to the president himself. So they're weighing, while we were trying to pass privacy legislation over the last few years, one of our mantras was keep Donald Trump away from it as much as possible. But actually, if you have the Biden White House engaged, that could be very, very helpful. And again, what's the downside in moving forward? There isn't much. And what's the upside? To my mind, privacy protection and privacy legislation, it's like the Sherman Act and the Clayton Act and the FTC Act of the progressive era, right? It is a hugely important issue about how we make our economy work for consumers, and how we give them trust in that economy.
And now you mentioned the progressive era. You and I talked earlier, you did mention there's maybe some parallels here to the La Follette era. And since you are speaking, with the La Follette School, what kind of
The Robert
parallels?
M. La Follette School of Public Affairs, yes.
Yeah.
Well, look, I think in the late 19th century, there was a problem with the dominance of large railroads and other companies, oil trusts, and a number of other large companies that banded together against consumers. A few states, particularly in the Midwest, I think Minnesota and Nebraska were actually among the first states that that passed laws, and eventually. And there's a very good book actually by Amy Klobuchar on antitrust, which talks about this that she published earlier, that was published earlier in this year. But and I think that movement, was crystallized in the progressive era reforms that we had on antitrust. I think today in privacy, you're seeing some of the same things. States are moving ahead of the national legislature, of Congress, in providing protections, but it doesn't quite fit as well as a national law should or would. So whether, from my perspective, whether that's an opt-in, opt-out approach like the FTC proposed, or whether it's something even more dramatic, but maybe a little more practical, like than the GDPR, that would be a major improvement. And you know what? These companies will not be going to the poorhouse, right? They'll still go on and they will figure out ways to monetize data in the United States as they do in Europe, right? Even under the GDPR.
So yeah, the GDPR. I mean, that this is the law of the land in a significant amount of the population in the world, but it's not for us here in the US. Right. Is there ever, could you ever see anything close to that happening here?
I do. I really do. And now I may be, when I worked for Senator Cole, he often saw the glass half empty, and I almost invariably saw it half full. But I do think there's the possibility. Again, consumers want it. Lawmakers seem to agree on most of it. The FTC itself, when we tried to get easier rulemaking authority, it was to do a privacy rule. And, the whole business community hated that idea, and they got to the Senate, and that's why we didn't get it. And now I think most of the business community sort of regrets that, because we would have done a rule. And the FTC has recently, right, again, if you do a rule under the easier, I'm sorry to get too detailed, notice and comment rulemaking, you can do it in 2 years, and you take, you put out a draft, you take comments, you bevel your draft, you come out with a rule. Under MAG-MOS, it has taken an average of over 5 years to do a rule. But I think if we knew then what we know now, we probably would have started a MAG-MOS rule. And it looks like the FTC, which has in some ways modified the procedures for doing a MAG-MOS rule, may go forward with a MAG-MOS privacy rule. I think it makes sense for them to take a shot at it. So I think one way or another, we're going to have better privacy protections soon.
So what does the antitrust approach look like, grappling with all the issues that we're looking at here?
Well, look, it's sort of two-pronged, right? One prong is enforcement, and you've seen the FTC and the number of state attorneys general bring a case against Facebook for monopolization. You've also seen the Justice Department under Bill Barr bring a case against Google for monopolization. And we will have to see, monopolization is very hard to prove. We brought several monopolization cases when I was at the FTC. We won one, and we more or less won. We did okay, but they were mostly in settlements and not in judge verdicts. So we'll have to see where those go. So that's the enforcement side, and there are more investigations of a variety of monopolists going on. The FTC also lost a monopolization case against Qualcomm last year in the Ninth Circuit. So again, it's if two companies conspire, that's a on the burden is on the enforcement agencies or the plaintiffs. The other thing that's going on, and I think it's really, really interesting, is again in Congress, the interest in curbing the power of particularly big tech. And so it's there. Well, President Biden had an executive order on competition in July. It touches on a variety of sectors, but particularly technology and large technology platforms. It's probably the most engaged a president has been on antitrust issues, I would say, since Wilson, right, or Taft, or Roosevelt. So that's a good sign. In the House side, the House Judiciary Committee has passed out legislation that would do a variety of things. I think it's 5 different bills. It would only one is consensus support, which is raising the merger fees to give the antitrust agencies, the FTC and the Department of Justice, more money to do the job they're supposed to do, but they're woefully underfunded. The others would require sort of interoperability, make mergers by big tech companies harder. There's a threshold of, I think, $700 billion for a company to be within the target of this law. So think of it this way: like Visa is under, Walmart is probably under, but Microsoft, Facebook, Google, Apple are all over the threshold. I'm sure I'm missing some company, but I don't think they care if I miss them. But these bills came out of the Judiciary Committee by mostly narrow margins. 2420, one of them, which would allow the breaking up of companies that have sort of conflicting lines of business, 2120. And the California delegation, because so many tech companies are in California, is not enthusiastic about it. And so right now, the House bills, and I think there's a lot of good in these bills, right? I think we do have too much concentration among some technology companies, right? They have dominant market shares. And if you had more interoperability in the porting of data, you might be able to create competitors, notwithstanding kind of network effects that sometimes tip to the largest company even more market share. So there's a lot of good in these bills, but we'll have to see what the speaker wants to do with them. They came out of Judiciary Committee in June. Maybe they get a vote this year. If they don't get a vote this year, that's not a great sign. And on the Senate side, the leading piece of legislation was introduced by Amy Klobuchar, she's the chair of the Antitrust Subcommittee from neighboring Minnesota, and that takes a different approach. What she tries to do is overturn a number of, some of us would say, cramped Supreme Court rulings of the last 20 or 30 years, to make it easier for agencies to win antitrust cases, to make it harder for large companies to merge, would sort of flip the burden from the government in some instances to the companies themselves to show that this is a pro-competitive benefit of the merger. And now she apparently is close to introducing legislation with Chuck Grassley of Iowa, your other neighbor, and who's been very progressive going back to when I worked on the Judiciary Committee on antitrust issues that would be more focused on large platforms. And again, Republicans believe that a lot of these large platforms are curating news in a way that harms them. Democrats are concerned about hate speech and concentration. And so we'll have to see where it goes. But I'd also say, Jessie, that it is easier, much, much easier. And I don't like to always admit this, but I was a lobbyist for a while, way back in the day. It's always easiest to stop legislation. Much easier to stop legislation than it is to enact it. So we'll have to see where these bills go. But there's definitely a growing movement, and so if not this year, then I think you'll see progress next year and in upcoming Congresses.
So another area I think in Congress where we actually have seen maybe not agreement about what should be done, but agreement from both sides of the aisle that something should maybe change is Section 230. Section 230 of the Communications Decency Act, which essentially it's platform immunity, right? So online platforms are not responsible for the content that their users publish on them. And I think we've heard from both sides of the aisle a variety of proposals. What do you think is the right way to approach Section 230 at this point?
So look, the platform immunity has become a problem in some ways, and there are multiple proposals from the left, the right, the center to modify Section 230, to modify Section 230. Having said that, and some of them are big proposals, like just take away the immunity and treat them like a publisher or like a newspaper or a TV station, right, for the content that they air. And some of them are smaller, like let's take away their immunity for this thing, right? I think there was one for child obscenity a couple of years ago. There are some thoughtful proposals on Section 230, but I would worry a little bit that if you take away all of the immunity, you might actually, it might be sort of throwing the baby out with the bathwater. You might actually create more problems in a couple of ways. One is the bigger platforms would probably have a lot more money to sort of lawyer up, and they can hire the best lawyers, and they can hire, spend the most money on legal arguments. So it might, in some perverse way, benefit the large platforms over the small ones. And then you might see, and again, another way that might happen is you might see sort of a crippling number of defamation lawsuits. Like you, my wife is a reporter, and she works at a major, she's a columnist and editor at a major newspaper, and you would hate to see that happen, because after all, these are outlets for news. So we'll have to. Tim Wu, my former colleague, now at the White House, has sort of somewhat surprisingly also raised concerns about Section 230 legislation. So I'm all for it to try to limit the hate speech, any bias towards a particular or against a particular ideology within the guardrails of legitimate ideologies. But you need to be sort of careful when you legislate something like this away. And I do think Section 230, served its purpose for the first 10, 20 years of the internet, right? Because you wanted to make sure that this new medium could be a source of information. Unfortunately, it's become a source of a lot of disinformation.
Yeah, don't we know it?
We do.
So another potential approach here is the FTC can promulgate rules. What kind of options exist there?
So it couldn't promulgate rules on Section 230.
Right. Oh, sorry. Veering away from Section 230, back to just privacy.
Oh, rules. Okay, on privacy and on antitrust.
Yeah.
I mean, we didn't use our rulemaking. It was pretty dormant. We thought about using it to stop some anti-competitive behavior by pharmaceutical companies, but we won a case in the Supreme Court. But the FTC, it's a new, I think, and actually very aggressive FTC, or it will be when the majority, right now it's 2-2. And so they may try to do rules on privacy. And if they try to do rules on privacy, that would be great. They're also thinking about doing a rule on non-compete clauses. That's a problem for low-income workers, particularly. If they're not really enforceable necessarily, but if you're a worker at McDonald's and, it says you can't go work for Burger King for 2 years after you leave here, you're not going to know it's not enforceable. So prohibition on non-compete clauses would be good. I suppose if the legislation in Congress stalls to curb the power and the market power of large technology companies, I would think that the FTC could probably promulgate a competition rule. Competition rules are easier to do than consumer protection rules. So when I said we didn't do many rules, I mean we didn't do competition rules because they're under the Administrative Procedure Act. They're not fast, but they are faster, and so I suppose if they wanted to, I hadn't really thought of this until you asked the question. They could try to require interoperability of large platforms. They could say that if you leave a large platform or even a small platform in a vertical where you have a dominant market share, or maybe all platforms where they collect your data, that you can port your data and go somewhere else. And maybe that would create a much more open and competitive internet among data collectors and social networks. So we'll have to see. Stay tuned.
Man, I have a million more questions from myself that I could ask, but I do want to get some more audience questions in. So, and this is a good one. Kind of dialing back to just the tracking of information. Are we just talking about tracking or also about manipulation of human behavior? And is that sort of a intertwined with privacy, or is it an entirely separate issue?
This is a great question. I mean, I think it's sort of intertwined with data collection and corporate responsibility. So anyone who read the Wall Street Journal series of a couple of weeks ago about Instagram, would come away saying there's a major problem here, particularly with young women, that Instagram causes for young women about body image. Okay, and then if you read some of or watched the testimony of Frances Haugen, I think that's Haugen, it just sort of reinforces that. So I was mostly talking about privacy when I was talking about, invisible data collectors, the cyberazzi, and I was also talking about the actual collection of data from consumers. But I think this is a really interesting area now, and it's conceivable to me that a state attorney general or the FTC is looking at this not for a privacy violation so much, but for a unfair, deceptive act or practice really an unfair act or practice by Instagram. And the way you get there, you have to meet a three-part test. There has to be harm, but it can be in the aggregate, and it can be that's prong one. In the aggregate, it can be to and it can be to, doesn't have to be to everybody, it can be to a significant minority. Then two, it has to be avoidable by the consumer. Well, you don't have to use Instagram, but if you're a teenage girl, maybe you pretty much almost have to. And then the third area is whether the harms to competition or consumers outweigh the third prong, outweigh the benefits. So it's interesting. I don't know what the agencies would do. I have a sense of what I might do if I were back there. But fortunately for America, nobody will give me that job again. And so we'll have to see. But I think that's a big problem. And, it may or may not be within the ambit of the FTC Act or state attorney general's generally parallel enforcement authority. Hope that answers that question.
Yeah, I think so. Another one.
Can I just say one more thing?
Yeah,
which is also, it's also about corporate responsibility. And here, it's a little unclear exactly what Instagram and others, knew. But if they knew this was a problem, the best response is you take action, right, of your own, right? Otherwise, problems like this fester and they become sort of public scandals, right?
I mean, is there any incentive other than just, I guess, morality and common decency to act on something like that, though?
Yeah, well, I think that's an important, those don't underestimate, most corporate leaders are pretty decent people.
Yes.
And don't underestimate those values, but I also think it's about protecting your brand, right? If you are sanctioned and if you are admonished by dozens of congressmen, at hearings, and it becomes that it's on the national news and you are investigated by Congress or you're investigated by a government agency for a violation and they sue you, that's not good for your brand, right? And so so there are lots of reasons, but and these are big companies, so they don't always know exactly what's going on at the time, in real time. But I would say, common decency, corporate responsibility, and self-interest are three good reasons to do the right thing.
Sure. Another audience question. In surveys, many people say they care about privacy, but their actual behavior would suggest otherwise. Does that actual behavior tell us more about people's actual priorities than what they may express if asked about it?
I think it tells us something, right? It tells us people believe in the convenience of the internet and the efficiencies it brings. You know, look. I believe in, I believe strongly in consumer privacy, but if I'm using Google, I don't always switch on incognito mode. I know it's there. I know just a couple clicks, maybe it shouldn't be a couple clicks away. That you can have someone not collect your browsing information, as I understand it. There's some smaller, DuckDuckGo and Mozilla have done some other things that are more consumer privacy friendly, and yet I don't necessarily use those services as much as I probably would like to or wish I could, because you do get benefits with dominance, right? And dominance in collecting information. So yes, it tells us something, but it doesn't tell us what it doesn't tell us, I think, and I don't know that this viewer disagrees, but what it doesn't tell us is whether, privacy is a right. I think it is. And whether consumers, and whether government, in a way that effectuates, a consumer's interest in Americans' interest in controlling their own data, whether government shouldn't set a standard that puts the burdens on companies to try to extract information with true consumer consent, rather than consumers, having the burden of trying to pull back claw back their information, which is a very hard thing to do. Right.
This is a broad question, but I think it's a good one. What does a successful but realistic remedy for big tech look like?
That's a great question. A realistic remedy for big tech. Well, first of all, I think there should be much more, I think consumers should have much more control over their data, right? That may in some ways restrict big tech. It will restrict everybody else too, broadband providers, online companies, Walmart, everyone. But I think that's important. If it were me, I would probably encourage mandatory licensing of competitors, portability, right? So that you might be able to create more competitors who could share, so consumers had more choice, right? I go back and forth about breaking up technology companies in this sense. I'm not convinced that it should be done legislatively. And by the way, if you break up a big tech company into 3 or 4 component parts, you might have 3 or 4 dominant companies, each of which get or 3 or 4 companies, each of which have a dominant share in their marketplace. It doesn't always happen that company A and company B are separated, and then company B goes into company A's market and company A goes into company B market. More often than not, it just does not happen that way, even if we would like it to. I'd like to see how the monopolization cases pan out, and that's very, very fact intensive. It's going to take a few years. It can't be. It's going to be done in the federal courts rather than at the FTC in its own administrative proceeding as an administrative judge, and it could try a faster case there, but that's not the way the commission is doing it, or the Antitrust Division, which doesn't have that option. So I'd like to see how they come out. If it turns out these companies are engaging in illegal monopolization, just like 35 years ago, we broke up AT&T. We can break up those companies, but I wouldn't necessarily want to do it by legislative. I mean, look, I think there's no consensus yet to do it legislatively, but I don't know that we would end up with greater consumer benefits if we did that. But if a court finds that, some of these companies engaged in monopolization, and that the best, simplest, most straightforward remedy is, rather than putting them under all sorts of behavioral requirements, is to break them up, I'm for it.
So, I mean, we've throughout the course of this conversation, Cambridge Analytica has come up, the Instagram, more recent stories about how Instagram has affected younger girls. And I think, every few months, weeks, years, we hear something else about how our data is being used, how our privacy is being exploited, I guess, by some of these companies. But there's a lot of news and there's a lot of things to get upset about. So from a public awareness perspective, I mean, what do you think is the way to actually get people to think people care about it, but to get people to actually continue to care about it and actually want to drive some change?
Well, the worst way to get more people to care about it is more stories about Instagram and more data breaches that, affect all of us, and more, bad corporate behavior by companies we haven't even heard of, but will hear of. I think the best way to get people involved, I think honestly, I think they would be very supportive of this. Whenever they're polled, they want to see more privacy protections for consumers and more control over their data. Children particularly, everyone believes that, the children should be more protected. But I also think it's time for lawmakers to do their job, right? They didn't go to Washington to just keep on getting reelected. And I'm not saying most of them did, because most of them actually care about legislating on both sides of the aisle. But I'd like to see them do their job and, refresh their legislating musculature, which hasn't had much activity over the last 10 or 15 years, and pass a privacy law. That'd benefit everybody. They'd be heroes.
So I think last question, the toothpaste, it's not out of the tube the way that you're telling it. You see room for change here. You said you're a glass half full guy. What's your words of optimism for people going forward in terms of what kind of control we can have over our data and what we may be able to change?
Every once in a while, Congress will surprise us, and they will do good things for the benefit of all Americans, and they'll do it in a bipartisan way. And I am optimistic. I am a glass half full guy. I think the toothpaste, will come out of the tube someday in a good way for consumers and privacy protection. And I do believe that this is something that can get done. And, someone or someones will be the next John Shermans and the next Claytons and the next Teddy Roosevelts, because they will be championing more consumer control. And that is my hope, and it is and I am at least cautiously optimistic.
Cautiously optimistic is pretty good.
Now I will say that David Brooks, who will be speaking later in the month at the La Follette. Here's David Brooks. You probably know him as a New York Times columnist. He's ethical, thoughtful. Probably know him from Brooks and Marcus on the NewsHour. He'll be at the Student Union October 27th. He's a little more pessimistic than I am overall, but he's a very moral, decent fellow, and I would encourage all of you who are tuning in tonight to come and see him at the end of the month.
Well, thank you so much, Jon, for this thoughtful discussion. Thank you to everyone who submitted questions or who just listened, participated. Thank you to the La Follette School, to the whole initiative, and just again to everyone who is here to help make this happen. It's been a great conversation, and I'm glad to be a part of it.
And thank you, Jessie.
All right. Good night, everybody.
Good night, everybody. Bye.